Perry v. Schwarzenegger, today's decision. Plaintiffs challenge a November 2008 voter-enacted amendment to the California Constitution, Proposition 8, or Prop 8, California Constitution, Article 1, Section 7.5. In its entirety, Proposition 8 provides only marriage between a man and a woman is valid or recognized in California. Plaintiffs allege that Proposition 8 deprives them of due process and of equal protection of the laws contrary to the 14th Amendment, and that its enforcement by state officials violates 42 U.S.C. 1983. The plaintiffs are two couples. Kristen Perry, Sandra Steyer reside in Berkeley, California, and raise 4 children together. Jeffrey Zerillo and Paul Katami reside in Burbank, California. Plaintiffs seek to marry their partners and have been denied marriage licenses by their respective county authorities on the basis of Proposition 8. No party contended, and no evidence at trial suggested that the county authorities had any ground to deny marriage license to plaintiffs other than Proposition 8. Having considered the trial evidence and the arguments of counsel, the court, pursuant to FRCP 52A, finds that Proposition 8 is unconstitutional and that its enforcement must be enjoined. Background of Proposition 8. In November 2000, the voters of California adopted Proposition 22 through the state's initiative process. Entitled the California Defense of Marriage Act, Proposition 22 amended the state's family code by adding the following language: only marriage between a man and a woman is valid or recognized in California. California Family Code, Section 308.5. This amendment further codified the existing definition of marriage as a relationship between a man and a woman in Ray Marriage Cases, California, 2008. In February 2004, the mayor of San Francisco instructed county officials to issue marriage licenses to same-sex couples. The following month, the California Supreme Court ordered San Francisco to stop issuing such licenses and later nullified the marriage licenses that same-sex couples had received. See Lockyer versus City and County of San Francisco. The court expressly avoided addressing whether Proposition 22 violated the California Constitution. Shortly thereafter, San Francisco and various other parties filed state court actions challenging or defending California's exclusion of same-sex couples from marriage under the state constitution. These actions were consolidated in San Francisco Superior Court. The presiding judge determined that as a matter of law, California's bar against marriage by same-sex couples violated the equal protection guarantee of Article 1, Section 7 of the California Constitution. The Court of Appeal reversed, and the California Supreme Court granted review. In May 2008, the California Supreme Court invalidated Proposition 22 and held that all California counties were required to issue marriage licenses to same-sex couples. From June 17, 2008 until the passage of Proposition 8 in November of that year, San Francisco and other California counties issued approximately 18,000 marriage licenses to same-sex couples. After the November 2008 election, opponents of Proposition 8 challenged the initiative through an original writ of mandate in the California Supreme Court as violating the rules for amending the California Constitution and on other grounds. The Supreme Court upheld Proposition 8 against those challenges. Strauss v. Horton, 2009. Strauss leaves undisturbed the 18,000 marriages of same-sex couples performed in the 4.5 months between the decision in Ray Marriage Case and the passage of Proposition 8. Since Proposition 8 passed, no same-sex couple has been permitted to marry in California. The procedural history of this action. Plaintiffs challenged the constitutionality of Proposition 8 under the 14th Amendment, an issue not raised during any prior state court proceeding. Plaintiffs filed their complaint on May 22, 2009, naming as defendants in their official capacities California's Governor, Attorney General, and Director and Deputy Director of Public Health, and the Alameda County Clerk Recorder and the Los Angeles Registrar Recorder County Clerk, collectively entitled the government defendants. With the exception of the Attorney General, who concedes that Proposition 8 is unconstitutional, the government defendants refuse to take a position on the plaintiff's claims and have declined to defend Proposition 8. Defendant interveners, the official proponents of Proposition 8 under California election law, called proponents, were granted leave in July 2009 to intervene to defend the constitutionality of Proposition 8. On January 8, 2010, Hak-Shing William Tam, an official proponent and defendant intervener, moved to withdraw as a defendant. Tam's motion is denied for the reasons stated in the separate order filed herewith. Plaintiff intervener City and County of San Francisco was granted leave to intervene in August 2009. The court denied the plaintiff's motion for a preliminary injunction on July 2, 2009, and denied proponent's motion for summary judgment on August 14, 2009. Proponents moved to realign the Attorney General as a plaintiff. The motion was denied on December 23, 2009. Imperial County, a political subdivision of California, sought to intervene as a party defendant December 15, 2009. The motion is denied for the reasons addressed in a separate order filed herewith. The parties disputed the factual premises underlying plaintiff's claims, and the court set the matter for trial. The action was tried to this court January 11 through 27, 2010. The trial proceedings were recorded and used by the court in preparing the findings of fact and conclusions of law, and the clerk is now directed to file the trial recording under seal as part of the record. The parties may retain their copies of the trial recording pursuant to terms of the protective order herein. Proponent's motion to order the copies returned is accordingly denied. Plaintiff's case against Proposition 8. The Due Process Clause provides that no state shall deprive any person of life, liberty, or property without due process of law. United States Constitution, Amendment 14, Section A. Plaintiffs contend that the freedom to marry the person of one's choice is a fundamental right protected by the Due Process Clause, and that Proposition 8 violates this fundamental right because, 1, it prevents each plaintiff from marrying the person of his or her choice. 2, the choice of a marriage partner is sheltered by the 14th Amendment from the state's unwarranted usurpation of that choice. And 3, California's provision of a domestic partnership, a status giving same-sex couples the rights and responsibilities of marriage without providing marriage, does not afford plaintiffs an adequate substitute for marriage, and by disabling plaintiffs from marrying the persons of their choice, invidiously discriminates without justification against the plaintiffs and others who seek to marry a person of the same sex. The Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. According to plaintiffs, Proposition 8 violates the Equal Protection Clause because it discriminates against gay men and lesbians by denying them a right to marry the person of their choice, whereas heterosexual men and women may do so freely, and disadvantages a suspect class in preventing only gay men and lesbians, not heterosexuals, from marrying. Plaintiffs argue that Proposition 8 should be subjected to heightened scrutiny heightened scrutiny under the Equal Protection Clause because gays and lesbians constitute a suspect class. Plaintiffs further contend that Proposition 8 is irrational because it singles out gays and lesbians for unequal treatment, as they and they alone may not marry the person of their choice. Plaintiffs argue that Proposition 8 discriminates against gays and lesbians on the basis of both sexual orientation and sex. Plaintiffs conclude that because Proposition 8 is enforced by state officials acting under color of state law, and because it has the effects plaintiffs assert, Proposition 8 is actionable under 42 U.S.C. 1983. Plaintiffs seek a declaration that Proposition 8 is invalid and an injunction against its enforcement. Proponents' defense of Proposition 8. Proponents organized the official campaign to pass Proposition 8, known as ProtectMarriage.com, Yes on 8, a project of California Renewal, Protect Marriage. Proponents formed and managed the Protect Marriage campaign and ensured its efforts to pass Proposition 8 complied with California election law. After orchestrating the successful Proposition 8 campaign, proponents intervened in this lawsuit and provided a vigorous defense of the constitutionality of Proposition 8. The ballot argument submitted to the voters summarizes proponents' arguments in favor of Proposition 8 during the 2008 campaign. The argument states, Proposition 8 is a simple and straightforward. Proposition 8 is about preserving marriage. It's not an attack on the gay lifestyle. It protects our children from being taught in public schools that same-sex marriage is the same as traditional marriage. While death, divorce, or other circumstances may prevent the ideal, the best situation for a child is to be raised by a married mother and father. If the gay marriage ruling of the California Supreme Court is not overturned, teachers could be required to teach young children that there is no difference between gay marriage and traditional marriage. We should not accept a court's decision that may result in public schools teaching our kids that gay marriage is okay. While gays have the right to their private lives, they do not have the right to redefine marriage for everyone else. In addition to the ballot arguments, the Proposition 8 campaign presented to the voters of California a multitude of television, radio, and internet-based advertisements and messages. The advertisements conveyed to voters that same-sex relationships are inferior to opposite-sex relationships and dangerous to children. The key premise on which Proposition 8 was presented to the voters thus appeared to be the following. 1. Denial of marriage to same-sex couples preserves marriage. 2. Denial of marriage to same-sex couples allows gays and lesbians to live privately without requiring others, including perhaps especially children, to recognize or acknowledge the existence of same-sex couples. 3. Denial of marriage to same-sex couples protects children. 4. The ideal child-rearing environment requires one male parent and one female parent. 5. Marriage is different in stature, depending upon the sex of the spouses, and an opposite-sex couple's marriage is superior to a same-sex couple's marriage. And 6. Same-sex couples' marriages redefine opposite-sex couples' marriages. The state's interest in an enactment must, of course, be secular in nature. The state does not have an interest in enforcing private moral or religious beliefs without an accompanying sexual purpose. Perhaps recognizing that Proposition 8 must advance a secular purpose to be constitutional. Proponents abandoned the previous arguments from the campaign that had asserted the moral superiority of opposite-sex couples. Instead, in this litigation, proponents asserted that Proposition 8(1) maintains California's definition of marriage as excluding same-sex couples, 2, affirms the will of California citizens to exclude same-sex couples from marriages, 3, promotes stability in relationships between a man and a woman because they naturally, and at times unintentionally, produce children,